Everybody, how you doing out there? Getting started today. We're talking about AEDPA. I'm here with Travis Williamson, who most of you know. He's been on my channel here a few times already. We're going to be talking about AEDPA, which is a good reason for why Travis is here, because obviously this is a pretty highly technical legal act or piece of legislation, and so having somebody who has the legal background here to help us go through it is obviously helpful. So, hello everybody. Hello. Everybody says hi. So,
hey, hello.
So, so we're going to talk about AEDPA today. I mean, and obviously I have some thoughts about it that you guys have heard in the past, but we're going to actually, go through it and get a better understanding of it, with the help of Travis, obviously. So what we got is a PowerPoint presentation and a few little things that Travis has picked out that he feels are relevant in helping to understand AEDPA and the interpretation of it and those sort of things. As far as going into any deeper case law, for those of you who are already thinking that far ahead, as far as going into any deeper on the case law on this, we won't do that today, but we are willing to do it in the future. So just so you guys know. And let me see. Is surely one of the worst statutes ever passed by Congress and signed into law by President the New Yorker. I agree. I mean, I don't understand how something that was supposed to apply to terrorists and death penalty cases somehow got applied to Brendan. I mean, Brendan's neither one of those things. And what's more, what kills me is that and the Supreme Court has recently even outlawed the death penalty for kids like Brendan. You guys might remember Seth Waxman was part of it. He actually became Brendan's lawyer when he was petitioning the Supreme Court. Seth Waxman was the one that argued it. And the Supreme Court has deemed that the death penalty doesn't even apply to juveniles yet. AEDPA still does. And I think that's alarming. Anyway. Any thoughts, Travis?
Well, it never ceases to amaze me the analogies you bring up, and I hadn't even thought of that. Here you have, it was a Texas case along with a Florida case. It was 2 or 3 cases that went up at the same time where a juvenile was involved, and they were trying to apply the death penalty, and then they just threw them all out at the same time and just said, no, you can't seek death penalty against somebody under 18. And around the same time, they reaffirmed that, you can't execute somebody who is
not fully there.
I don't want to say mentally retarded. I just did. That low intelligence, whatever that is, and whatever the current term is, but
seemingly not in full control of their capacities.
Good exercise in the law of unintended consequences.
Right. Yeah. So that's a good starting point, I think. So
okay. Well, I'll just go through this. There's only about 4 or 5 slides, and then we're going to switch over to a Word document and go through a couple of things in a little bit more detail. I wasn't having some trouble getting stuff saved. So
bummer.
Wasn't able to finish the PowerPoint, but let's just start in here.
That's all right. We're going to revisit this issue anyway, so
yeah,
we'll cover the basics.
Yeah, real basic, and to get everybody up to speed and on the same playing field, so to speak. So we're talking about the Anti-Terrorism and Effective Death Penalty Act. This came up in MAM2 and was discussed. It's referred to, as Eric Pose would say, AEDPA, or
AEDPA.
Some people just refer to it as AEDPA or AEDPA if you're from down south. Passed in 96. And so how did this come about? We alluded to that just before we started. So there were a few things going on. As MAM 2 showed Timothy McVeigh, the Oklahoma bombing
Right.
had occurred. They were all about giving him the death penalty under the federal statute. First one given the federal death penalty in a long, long time.
Right.
They were fearful that, it was going to drag out the average time for a death penalty case. Remember what the heading of this thing is: anti-terrorism and death penalty.
Yeah. Right.
Effective death penalty.
Yeah.
So the average time was 8 years for someone who had been given the death penalty for the sentence to be executed upon. For some people, that's way too long. For a lot of people, that's still way too short. If the appeals process is designed to prevent an innocent person from being executed,
Right.
8 years. By that time, the time that they passed this, exonerations for people on death row were rolling in. So you kind of had this mob mentality going on.
Yeah.
The World Tower bombing had occurred,
World
and
Trade Center,
that
right?
trial had occurred, and seeking the death penalty and appeals and whatnot. And Newt Gingrich, the contract with America, I don't know if anybody remembers that, but there was 10 points on there, balanced budget, a bunch of things. But one of them was to reform habeas corpus. And
Right.
it had actually, they tried to pass similar legislation the year before, and it failed. And then 96 it passed, and it was a major compromise. And the NRA was involved, and of course, all these different special interests. And so
Right.
it's, the proverbial joke about the elephant. And that's what you end up with: an animal that looks like an elephant. If you go through the legislative process, you end up with a bunch of compromise.
Right.
So AEDPA included habeas corpus reform, but it was reform for all cases, not just death penalty cases. And
But it
so,
should have been just for the cases that this applied to. That's the problem with it. That's exactly
yes,
the problem with it. I fully get what it's for, and I fully get why it was conceived. But what I don't get is how all of these things ended up applying to cases that have nothing to do with the death penalty or terrorism. That's where I don't understand where the politicians that drafted this thing were going. And obviously it's that bit that led the Supreme Court to interpret it the way they did.
Yeah.
And I have some ideas about the way that they interpreted it as well. But
There's always been, and this was mentioned in MAM 2, there's always been this doctrine of finality. Once you had a jury come in and decide a case, the courts, they shift their focus from ensuring a fair trial with, procedural due process, all the rights attached, Fourth Amendment right to free from unreasonable searches and seizures, Fifth Amendment right not to be coerced into giving a statement against yourself,
right.
And Sixth Amendment right to counsel, et cetera, et cetera. Once a jury reaches a decision, then the doctrine of finality applies, and it flips, and then the courts take an opposite view. Well, if the jury decided, unless you can show something really out of the ordinary, we're going to stick with it. So here's one thing to keep in mind if you're somebody that's kind of new to this thing. So Brendan and Stephen were charged with state law crimes: murder, sexual assault, mutilation of a corpse, whatever the case may be, those are state crimes, as opposed to a federal crime like income tax evasion or campaign finance, a federal campaign finance law, or trying to bribe a federal judge. You know, there's a bunch of federal crimes, a bunch of state crimes. Sometimes they overlap, but in this case, these are state law crimes. So Wisconsin prosecuted them because they had jurisdiction. And so the appeals process, if you disagree with the jury's verdict, have all of these you have this appeal process, and in Wisconsin, you appeal to the Court of Appeals, and which Brendan did, and they disagreed with him. He brought two claims. His said his confession was coerced, and he was denied his right to counsel because he was given Lynn Kaczynski.
Right.
And so they denied, the Court of Appeals of Wisconsin denied his appeal. He then appealed to the Wisconsin Supreme Court,
which denied to hear him.
Which denied to hear it. It's discretionary whether they'll hear it or not. And they said, no, the Court of Appeals got it right. We're not going to hear it. So then he had a right of federal habeas corpus. So that's what we're talking about here. And what AEDPA did is basically tie the hands of federal court judges to look at whether a state court, a state appellate court, correctly interpreted the Constitution. So it was passed, they mentioned this in MAM2, bipartisan support, 91-8 in the Senate. That should be 293, 193 in the House. Placed strict timelines on people, and it also only gave you one federal appeal. Used to be you could, if you really came up with something legitimately new, you'd filed a petition for habeas corpus in federal court, that was denied, and you legitimately came up with something new, you could file another one. That is no longer allowed, period. So even if you find something ironclad that shows you're innocent and the state rejects you, you do not get another bite of the apple in federal court, which is why we're at with Brendan. He's got very little left, but he does have stuff to do, and we can talk about that if people have a question. Clinton signed it into law. He said at the time it was not his intent to constrain federal courts in their ability to review constitutional violations. Here's the actual record I dug up, the constitutional record, a portion of it. This is Senator Feingold on the Senate floor talking about why he was against it. He was one of eight senators who voted against this thing. And here's what he said. A recent March 20th editorial from the Milwaukee Journal Sentinel. Isn't this interesting?
A needless overreaction to terrorism.
And look at how the paper in Milwaukee, I don't know how big a paper that is. I assume it's the main paper, but I don't know. A needless overaction to terrorism. Criticize these provisions. Now, this is his words. Pointed out the fallacy of the alleged link between habeas reform and terrorism, or that these provisions will have any deterrent effect. And now he quotes the paper. It's difficult to see how the limits on appeals by prison inmates would deter terrorism. Most such prisoners have been convicted of ordinary, not political crimes.
Right.
Besides, many terrorists are willing to undergo punishment, even death, for the causes they believe in. That's the end
Right.
of the quote from the paper. Then he goes on to say, the inclusion of habeas reform in this legislation has very little to do with terrorism and a great deal to do with advancing an agenda which has previously languished in the Congress. That was Gingrich's contract with America. Just as
Right.
I oppose those law enforcement provisions which raise constitutional concerns, so too do I oppose these proposals. We should
Right.
be just as wary, and this had something to do with the NRA too. I think.
So when it comes down to it, all the habeas crap was just literally tacked on to something that was well-meaning.
Yes, 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 yes.
Yeah.
It became political. We should be just as wary of proposals which forsake constitutional protection in the name of habeas reform as we are of those which do so in the name of expanding wiretap authority. Because at this time, they were also, as part of this thing, wanting to expand wiretaps, the ability of a federal prosecutor to go in, send an FBI agent in to court and get a wiretap. So, I just wanted everybody to see the votes. It's 91-8, but
Oh, what do you know? McConnell's part of the
there's
91.
Feinstein, Graham, Lindsey Graham,
Right. It may have gotten
Warren
bipartisan
Hatch.
support, but I mean, it's still
Yeah,
scary
but
because, I mean, it was a good bill. Had they not tacked on a horrible bit that literally just strips
right.
Americans
This
of
is
their
what
rights.
happens if you don't give your senators and congressmen the fortitude to say,
Yeah.
hey, look, it's just, yeah, there's a lot of great stuff in here, but um, there's too much that's bad. And
Yeah.
here's the nays.
I mean, when it comes down to it, how in the hell this bill it was affecting Brendan, who is he's neither eligible for the death penalty, and nor is he a terrorist, and so it just pisses me off that this even applies to him.
So
Really.
then you get this law and order mentality at the time and this mob mentality. Um, Supreme Court in its interpretation of language has imposed greater and greater restrictions. Now, when we tell the state courts that the Constitution was violated, state court can't just be just wrong, that they just made a mistake. Have to show that the state court made an
An
unreasonable
unreasonable mistake.
mistake. And what's unreasonable? At the time, 99% of federal habeas petitions were denied. There was really no need for this legislation. This is a quote from a Supreme Court case or a circuit case that said this was their interpretation of it. Expressly intended by Congress to sharply curtail the right of state prison inmates.
Right. I get that was their goal here, but it's still not good. It's not just that goal in and of itself is anti-American, in my opinion. But yeah.
And so they got this intent from this language.
Yeah.
Was contrary or involved in unreasonable application. That's straight from the statute. That's what Congress said. And all they were trying to do is, hey, when you review these state court decisions, we don't want you reversing state courts if it's a minor error.
Yeah.
And they said clearly established federal law. And so if the
that set
Supreme
the bar
Court
way
hadn't
too high because they don't decide enough.
Yeah. So, if it's the Supreme
Really
Court hadn't
unreasonably high.
decided that it's a violation of cruel and unusual, Eighth Amendment violation, cruel and unusual punishment to execute a juvenile. They hadn't decided that yet. Yeah, federal circuit courts should not be overturning state courts if they allowed at that time the execution of a juvenile. That's what they were saying. And then, but this is where we've ended up. So here's a representative case. This is a fairly well-known case. You sue, typically when you bring a habeas corpus, you sue the warden of the jail
Right.
that you're in.
Which is why Dassey was always referring to Michael Dittman in his.
Yes. Yeah. So you name the person that's holding you. And this is a snippet from the decision. This standard is difficult to meet. That is because it was meant to be, as amended by AEDPA or AEDPA, as Eric Ose would say. Stop short of imposing a complete bar on federal court relitigation of claims already rejected in state court. So the author of this opinion saying, in his opinion, AEDPA is as close as you could come to being a complete bar on federal relitigation of claims. Yeah. Well, that's not what the statute said. It just said if it was contrary to or involved in unreasonable application. Right. And so now you see it morphed from, we don't want you overturning state court decisions where the Supreme Court hadn't spoken, or unless it's an error. Well, now it's it stopped just short of imposing a complete bar on federal court litigation.
To where that basically no what is it, how they refer to it, no right reasonable minded juror could
right here disagree. As condition for obtaining habeas corpus from a federal court, a state prisoner must show that the state court's ruling on the claim being presented in federal court was so lacking in justification that there was an error well understood and comprehended in existing law beyond any possibility for fair-minded disagreement.
And that is just such a ridiculously high bar. That was just like, that is just a ridiculously high bar that they've set there.
Another way to say it is, they can issue a writ where there's no possibility fair-minded jurists, that's judges, could disagree that the state court's decision conflicts with the court's precedents. And then that's what you can go ahead and let me turn off screen sharing, and then we can finish talking about this stuff.
All right, how you doing, everybody?
You there?
Hello?
Hey, can you hear me?
Yeah. Is it still going? It's still going.
No, we're good.
It kicked me out of the. That's really odd.
Right? We good? Okay. All right.
Take it over, Travis.
Would have been interesting. I don't like touching any of that stuff. I don't, I'm not
I think I accidentally hit like F8 and somehow it like booted me out of the Hangout. Like, I don't know how it boots me out of my own Hangout. I'm the one going live from YouTube, but
I knew that was you, of course. Couldn't have been me.
all right. So yeah,
So
so talking about AEDPA, I mean, for me, the big takeaway is how in the hell, and you say it's was it Newt Gingrich and his contract with America or whatever, but the whole thing is it seems to me that this was all a well-meaning act, the way it started, but then somebody got the bright idea of tacking on stripping Americans of their habeas rights, and tacked it all onto this thing, and that's really the problem with it. If it had stuck to the original purpose it had, it would have been just fine. It would have been a good piece of legislation.
yeah, and that's a common thing. We call it the law of unintended consequences.
Yeah.
And something sounds good on paper, and then either because of um, subsequent court decisions or not thinking the thing through all the way, you end up with these really absurd results. And so that's what happened here. But in this particular piece of legislation, people were warning about it right from the get-go, and
Yeah.
they said, you're
Gutting the habeas
eight
writ.
senators were saying, the right of habeas corpus is sacred. You don't mess with habeas corpus. It's
Right.
only been suspended just a couple of times, and always when we're in a full outright war.
Right. Okay, so let's see what Allie says. The only cool law that was in effect was the one that came because of Stephen, that they had to record the interrogations. I guess they forgot Fox Hills. I don't know that came from Stephen, but there was a case in the Wisconsin Supreme Court that resulted in juvenile interrogations. The Wisconsin Supreme Court was the one that ordered them, and it was interesting because they did it basically without the legislative branch. They just kind of ordered it on their own, if I remember correctly. You still there, Travis?
No, so for many years, about the last 20 years, states have been looking at and passing a lot of reforms on how the taking of statements or interrogation of juveniles should take place. Even Texas, in the last 10 or 15 years, has passed statutes about contacting a parent has to be notified, et cetera,
Right.
et cetera, et cetera.
Right.
There's a case out of California. It's absolutely horrible, but this 19-year-old kid out of Sacramento went down to give a statement, and he says two things. He says, do you really think I should be doing this without a lawyer? And then he had a letter from his father, and said, well, my dad wants me to ask for a lawyer. And he said, oh, you don't need one. And, they go ahead from him. And the California court said, no, he didn't clearly invoke his right to counsel. And then it went to the Ninth Circuit Court of Appeals in San Francisco, which I've argued in front of.
Yeah.
And it was a 3-person panel. And they said, nope, that's enough. I mean, if you're asking if you're saying my dad wants me to ask for an attorney, then, he's asking for an attorney. Then they went to an en banc. They agreed. It went to the Supreme Court. The Supreme Court said, well, you didn't explain enough how this is a clear violation. It was really looking kind of iffy for this man, and they sent it back and said the Ninth Circuit looked at it again, and they went ahead and ruled the same way. But there were 5 dissents saying, it's not clear enough. I don't know how clear you could be. Say, you think I should get an attorney for this, something to that effect, and then here's a letter from my dad. He wants me to have an attorney.
It seems to me that's just a reinforcement of the original statement. So I don't understand what's me. Right. I don't know what there is to misinterpret, but
yeah. And if anyone's interested in looking that up, the name of that person is T.O. Sessoms, Sessoms.
Okay.
And they ended up having to grant habeas corpus relief for him twice. It's just, I think, and these judges that were dissenting were like, well, we think this is clear law that California violated. But, we're worried about the Supreme Court if they're going to send it back to us again. And they talked about deference. It's more about, you should defer, should give deference to the state. The state should be the one deciding, but it's just a load of crap. It's the function of the court, the function of the judge isn't be on the prosecution team. Function of the court, the function of the appellate court is to protect the citizen from government, even if it's not popular. That's their function.
Right. Yeah.
And unfortunately, voters hold these elected judges accountable if they make an unpopular decision. And, it's, they get rid of them, and, they put somebody in law and order.
Yeah. Yeah. So I don't know. So I guess with that guy you're talking about there, obviously the Supreme Court, you're saying of the United States, right?
Yeah.
And ended up going against him and overturning the en banc from California.
Right. They said, no, we don't feel that there's no possibility fair-minded jurists could disagree. So they sent it back to the Ninth Circuit. And they just rewrote their opinion and said, well, okay, we'll take another stab at explaining why California violated this kid's Sixth Amendment right to an attorney.
So basically the en banc majority rewrote their opinion to send it back to the Supreme Court, or what?
It was up to the state then if they wanted to take another shot at appealing it to the Supreme Court. And to be honest, I don't know if they just didn't accept cert or what they did. I don't recall a Sessoms 2 in this. The first one that they reversed, it was summary. They didn't even issue an opinion.
Yeah.
They just ran summarily reversed. And so I think they just fashioned their decision better.
Yeah. I don't know. Seems disturbing to me that, I don't know, that it seems like our government is so hell-bent on trying to take away rights. It's kind of a disturbing
This is
trend.
Exactly what he said. Listen to this. You sit him down and he says, quote, "There wouldn't be any possible way that I could have a lawyer present while we do this," end quote. And he also says,
Right.
"Yeah, that's why my dad asked me to ask you guys, give me a lawyer."
Right.
And they're like, "Well,
Convincing him he didn't need
his
one?
dad asked for a lawyer, but he didn't." Yeah, I'm just like, yeah, talk about
No, he said his dad
getting
asked him to ask. So, you
listen
know
to
what I
this
mean? If we
one
follow the
judge.
wording, right? My dad asked me to ask for a lawyer. Is that what he said? So literally, he's asking. His dad asked him to ask, right?
Right, and they're saying, well, his dad asked for him to have a lawyer, but he didn't. You have to personally ask for a lawyer.
Right.
It's just,
Yeah. So I was just, by going by the wording, I feel like the kid asked. He may have been prompted by his dad, but he asked. I don't know. It's just by my looking at it anyway. Something else I was going to say.
yeah, I said, uh, judge, one of the judges took a hard line, wrote that Sessome's first statement was punctuated with hesitation and condition and phrased in the negative. That was the one. There's no way I can have a lawyer for this, can I? And then the second statement about the dad, he said, as for the second statement, a reasonable jurist could conclude that telling a detective, "My dad told me to ask for a lawyer," is different than saying, quote, "I want a lawyer," unquote.
Yeah.
That's just absurd.
Absolutely.
Um, but this was a well-liked preacher in Sacramento who was murdered.
Yeah. I would argue that the fact that he's asking that way without fully understanding why he should want and need a lawyer just proves that he's just not capable of surrendering his rights, his habeas or his Miranda rights, or any of those things. That's by him being wishy-washy and asking for an attorney, like his dad told him. I mean, that just tells me he doesn't understand his rights well enough to know that what he's doing.
Listen to what Judge Kaczynski of the Ninth Circuit said. And this applies to, of course, Brendan and Stephen. Judge Kaczynski stated, "It's just as well that our view doesn't command a majority." And he was one of the dissenters who was dissenting reluctantly. Basically, as protesting that AEDPA was tying his hands,
Right.
and saying, yeah, I don't agree, but I think AEDPA we can't rule. But he goes on to say,
Right. Okay.
if the state of California can't convict and sentence Sessoms without sharp police tactics, it doesn't deserve to keep him behind bars for the rest of his life. He goes on to say, when courts bend over backwards to salvage evidence extracted by questionable methods, keep this in mind in light of the Seventh Circuit's decision in Bonk, overturning Judge Duffin's decision. When courts bend over backwards to salvage evidence extracted by questionable methods, they encouraged police to take such shortcuts rather than doing the arduous legwork required to obtain hard evidence.
Right.
Isn't that a great quote?
Yeah. Yes, absolutely.
Showing, Brendan's case is going to have far-reaching implications for a while.
Right.
Wiegert and Fassbender, I'm sure feel vindicated. And I mean, just look at Lynn Kaczynski, how
Yeah.
elated he was when he got the news.
Yeah.
Oh, well, at first he's like, well, I guess this is good news for Brendan. And then, well, I was glad to see when he got the, word that Mbank reversed it. He's reading through it. Well, I'm glad to see that they away. And I
Yeah.
was the one who set this whole thing up to
Right.
begin with. And
Right.
I was the one to preserve, I just don't,
Trying to take
know
credit for, yeah.
don't know where they get these people.
Yeah. Trying to take credit for what Steve and Laura had done. Yeah, I know. Ridiculous. That guy. Ashley wants to know if public defenders are made available during interrogations. Are they ever made available during interrogations?
It
Public defenders, that is?
varies jurisdiction by jurisdiction. Some states, before you can talk to a juvenile, you have to bring in a public defender.
Mm-hmm.
That's very few states. So most of the states, that's not the case. I believe in the UK, you have to, you can't question a juvenile without an attorney.
Right. Yes. In the UK, yes. Actually, let's see. Steve Moore said that when he would try to take anything to the U.S. District Attorney, if he didn't if he didn't do it all just right, they would basically just like, get out of here, kid. You're bothering us. Because especially when it came to juveniles, if he had any kind of an inkling that the kid might be limited, he would have to immediately call the U.S. District Attorney's office so that they could determine what he needed to do, what safeguard he needed to take, so that whatever he ended up getting from the interrogation or whatever, that it would end up being able to hold up in court. And the U.S. District Attorney has a much higher standard than it seems maybe a lot of the kind of state courts have, or the state agencies have. It seems like the U.S. District Attorney, by listening to what Steve Moore was saying, they just have a much higher standard. I don't know.
I saw that interview, and U.S. attorneys are.
It leads you to believe that they don't take no crap in federal court. So it leads me to believe that AEDPA really is tying the hands of the federal courts, because I got to imagine they see a lot of this crap and want to just toss it the hell out.
Yeah, you really have to dot your I's and cross your T's in federal court. But it doesn't mean that you don't have to be ever vigilant of the FBI crime lab, ever vigilant of federal law enforcement agencies or individual detectives, or even a particular federal judge. You got to be ever vigilant. But as a whole, it's higher caliber, and they're dotting their I's and crossing their T's.
Right. Yeah, I just judging by the way he talked about the hoops he would kind of need to jump through, and listening to him talk about how that was an ever-present concern in his mind when he was chasing down the bad guys, was making sure that he was going to be doing it in a way that was going to conform with the U.S. District Attorney's wishes.
And again, it's these local guys. There's such huge pressure to make an arrest, and whereas federal guys, it's there's this layer. It's like there's this layer of independence.
Mm-hmm.
They're not going to sacrifice their credibility or their reputation. Although the FBI lab has had some problems here and there,
right.
But overall, nope, sorry, we can't get there for you on this.
Right.
At least not at this time. Get us more, and we might have something. But
well, I will say that Steve Moore did allude to the fact that he thinks, because when I said, "Oh, so the states just don't hold that same standard," he was like, "Whoa, I'm not saying everywhere in the United States is like this area in Wisconsin." He says, "I think there are a lot of states out there that do actually have a high standard that approaches the U.S. District Attorney." But he's saying he was just pointing out, but I don't know that it's everywhere, and certainly not in that area of Wisconsin. So let's see what else we got here. The main thing I want to say, to, I don't know, kind of wrap up here. We'll see if Travis has any closing thoughts either. But for me, the whole thing is that Timothy McVeigh and 9/11 created a situation where our politicians were able to do this. And I don't personally, if it had just stuck to death penalty cases and terrorist cases, I would not have any qualms with it. I would not have any issues with it. But it went too far. It went beyond that and gutted our habeas rights from us as Americans. And that's a problem. And it's only thrown into sharper relief and thrown into sharper focus when we see a kid like Brendan getting denied help because he can't get through this AEDPA wall, and this AEDPA wall shouldn't even exist for him. He's not facing the death penalty, and he's not a terrorist. So the fact that this wall is even there preventing him is for me a problem. AEDPA overstepped. We allowed our politicians to do this because we were a bunch of scared little kids, basically. We were scared of these terrorist acts. We were frightened, and as frightened children, we allowed our lawmakers to do this, and that's really the way I feel about it. It's
well, and so it used to be the federal
and what
courts.
did we really gain?
Yeah,
Sorry, go
you
ahead.
used to have this court of last resort really being the federal habeas corpus process, and you had it's like, okay, well, the Court of Appeals in my state, they're all on the take, or they're all corrupt, and in the Supreme Court of my state, they decide not to hear it. You always had the right to have a lifetime appointed judge who had no fear of any political outfall based on his decision. Nobody's going to boot him off the bench because people didn't like his decision. You always had the right to go to there and look at it, what we call de novo. Look at it anew. Look over everything that the attorneys were willing to present, and you knew you at least had a clean shake that you're going to go ahead, present all of this. Here's all the problems with the investigation. There's, all the problems with the search. Here's all the problems with, what my lawyer did or didn't do at the time of trial. Here's why my confession was coerced. Here's what other constitutional problems or challenges were. You knew you were going to have that process where they were going to look it over and make the call. And then if you didn't like that, then you could appeal it to the circuit court, and you'd have another shake there too. But to limit it to only where no reasonable jurist could disagree, you basically, what that one judge said, it wasn't a total bar to habeas corpus relief by the federal courts, but it's just one step below it. And it was completely different prior to 96. And if you look at, so now you have the Ninth Circuit Court of Appeals, which is going to be on the other end of the spectrum as the Seventh Circuit. And you've got even there, 4 or 5 judges dissenting after they were reversed the first time, gets sent back. The 19-year-old still wins, and you have 4 or 5 judges still dissenting, saying, under AEDPA, we shouldn't be finding in favor of this guy. That's a scary, scary thing. It basically means you have no federal habeas.
Yeah, it's basically that's what it's suggesting. Yeah, absolutely.
And if you look over the years, how many cases have been reversed at federal habeas, and to know that we're losing that ability should be scary, but it's not. But it should be.
Julie's asking, what happens when you suspect a jury is corrupt?
What happens when you suspect a jury was corrupt? So,
or corrupted?
A case can be reversed based on juror misconduct. You have to go in and with investigators and hopefully get one or more to open up about what the misconduct was. Discussing things like say, hey, I looked this up on the internet, or I went over to the crime scene, or I did my own investigation, or that came up in West Memphis 3. One allegation of juror misconduct, and then another juror came out later, and one juror supposedly said, "Look, I know these boys," or something, and there's no question they did it, and just improper stuff. But it's extremely difficult to get a case reversed based on juror misconduct. You're gonna need a couple of 3 affidavits saying that.
Couple 2 tree.
Yeah, couple of 2 or 3. But one person changing their mind a month later doesn't do you any good. And I was pressured into it. There was 11 of them and 1 of me, and they just kept pressuring me and pressuring me. That ain't gonna do it.
Yeah. Let's see.
It's got to be somebody, that lied during voir dire. At any of your family or close friends in law enforcement. Nope. And they clearly have family or friends in law enforcement.
Yeah.
Something like that, where you can get them on that, or where they violate the judge's instructions about not discussing the case, et cetera, et cetera.
Right.
And I don't know, there's been discussion. Well, it was this many to this many at this point, and then somebody else got on, and all of a sudden it flipped. But juries can reach decisions in a lot of different ways where there's nothing improper that went on. Sometimes they go home and sleep on it, and they were 8-4 for guilty, and then they come back and they're 12-0 not guilty. You just don't know, and you can't unless you've got a juror with an affidavit under oath saying,
right, something untoward happened. Right.
Yeah, they brought in a map of this, or they talked about this, or talked about that. Just not going to get anywhere with it. Did I answer Julie's question?
I think so. So,
Well, Julie
Let's see.
said they had family in law enforcement. What I meant was if a juror is asked during voir dire, the process where they're questioned, if they're you ask potential jurors questions to see if they're going to be biased for a particular party or prejudiced against a particular party, and you ask them a direct question to figure out if they got bias and they lie to you. That's one of the grounds.
Right.
If they didn't lie about, you're not, they're not asked, you have family in law enforcement, or if they're asked, you have family in law enforcement and they were truthful, um, you know, you have to exercise the challenges.
Yeah. Angie Norton's asking, so how do we change it? What do we say to our members of Congress or Senate to try and get AEDPA modified or AEDPA?
Read that to me one more time.
So she's asking, what do we say to our members of Congress or Senate to try and get AEDPA modified? Like what
Yeah.
can people do?
Yeah. So I was looking, there's been a few attempts to actually reverse this part of AEDPA. Senator Moynihan from New York, within a year of it being passed, went in, and the bill failed. It went nowhere.
Right.
Um, you, it's going to take an issue, and it might be, it might end up being this case when it's all said and done. If
Yeah.
it comes out the way we're hoping it comes out, that um, yeah, they proved these guys actually innocent, and you didn't provide a safety net, um, and you know we want you to pass the Brendan Dassey law
Right.
on habeas corpus. I'll tell there's another thing. Laura Nyrider, uh, she just gave a talk. I think I sent you the link, Eric Jose, on it.
Yeah.
And
For her and Steve Drizzen, you mean?
yeah, they're
Right.
they're doing a symposium at the law school this spring. I haven't been able to find the dates yet, but I'm hoping to send you and Allie
Allie.
there. But they're having everybody. They're having the people that wrote the brief for Brendan. They're having all of these people.
Oh, Seth Waxman gonna be there?
Pardon?
So you said the people writing the brief. You mean the Supreme Court brief?
Yes.
Oh, so that'd be Seth Waxman. That'd be
Yeah.
cool.
Um, they're all coming in to talk about juvenile confessions, and uh, so they continue to try to shape things in the court, but it'd be the perfect opportunity about, because they've talked about, well, what are Brendan's options now? So
Right.
they say, well, now that he's exhausted his federal appeal, and AEDPA made it clear you only get one shot. He can't he, he can't try and
You
come up
can't
with
bring
something
another
new in
federal
federal
habeas
court.
crate.
So
Right.
it's either outside the court system and getting governor to grant him clemency, or finding new evidence of a constitutional violation, which would be Brady. So if he can bootstrap something that Kathleen finds, like the computer thing,
Mm-hmm.
if he can bring in a clear Brady violation that he hasn't already asserted, he can go back into court, or new evidence that shows he's actually innocent. He can go back into court.
Right.
You got to be careful when you go back in, because the court looks at everything that you should have knowledge of at that time. So if he goes in and files a motion in 2019, they're going to charge him they're going to hold him accountable for having knowledge of everything that's possibly available on that date in 2019. And he doesn't discover that until later. He can't bring that. See, that's why you see Kathleen Zellner being extremely careful about when she files this stuff. She basically put that one appeal on hold, filed a motion for scientific testing, and then pursued it that way because she wanted to make sure she had everything she possibly could before she pursued an appeal.
Right.
Who was asking why? Let's see.
We got perplexed cutie in the chat right now, so she's in there arguing with people about the juries, and the importance of juries. I actually think I agree with her today. I agree that juries are important. They're the thing that makes our system fair. And I don't know the question you were referring to, Travis.
Where's Roel from that was saying, why don't we get rid of the jury system?
Oh, yeah. So that's what she's referring to. So it says, Laura, why is the jury system more fair than combined judgment of several judges? To me, because you're filtering through a constant stream of new people that can't. Nobody. Basically, it's hard to buy jurors because you don't know who they are until a certain point in every case. Yeah. So if there were judges, people would know who they could go to bribe or to corrupt things. There would be a very easy place to go, essentially. That's why.
Yeah. How long do you think the trial would have been if it was just Judge Willis and no jury?
Right.
Or Judge Fox? That's the alternative.
Yeah, I agree. It's not good.
You know, at least Strang and Beauty kept him out 3 days. You know, I mean, you don't want somebody like or Judge Angie. Could you imagine? She was, you know, you're going to her on guilt innocence. I mean,
oh yeah.
The defendant has the right to waive a jury trial, and in some cases that's prudent to do. But
not here.
Yeah, I don't know where Roel's from, but in the United States, like in England, the UK, Canada,
she's okay. Roel's from the Netherlands, saying that cases like this will be done by at least a 3-judge panel, sometimes more.
Brendan had a 7-judge panel
at on bank,
you know, trained in the law. Now the Netherlands kind of different. That's where the international court is at The Hague, and I know people that work for that court. I know that, you know, The Hague has produced very prestigious jurists and tribunals, but no, over here, based on our history, we don't trust we don't trust the government make the right decision. We feel that 12 lay people can get it right, and they do most of the time, but it's based on what they're presented.
Yeah, certainly. I think jury's the way to go, personally. It's just like I said, because if it was just judges, the people who want to corrupt the system will know right where to go to corrupt it. It makes it just right there and easy to point to.
Do you know what the average height of the average male in the Netherlands is?
I don't. What is it? Obviously you do.
Do you know, Eric Jose?
I don't. Or you want me to ask?
No, I know the answer. Do you know?
Oh, I don't know. I don't.
6'1". It's the tallest tallest country
Tallest average, right?
in the world. And then, you know, they're a monarchy. Do you know who the name of their king or queen?
Do I know the name of their king or queen? No, I don't.
Nobody knows the name of their queen.
Let's see.
What's
Roll. What's the name of your king and queen?
very good, Ryan. Ding, ding, ding. Okay, good.
Oh, Beatrix. So, and Maxima.
Angry Scotsman's on. I don't want to go to the other subject yet, but
Yeah. Yeah, he's on there. So he's going to be
no,
havering later about
yeah,
a birth certificate for Captain Crunch that he has, although it's handwritten in clearly in his handwriting. So I don't know how much weight that's going to hold in the court.
so Hall correctly the U.S. adopted jurors because some trials in the U.K. were corrupt. Well, the most famous case is William Penn, and he was tried. And back then, the king could put jurors in jail, but they didn't care. Those jurors said, "Go ahead, put us in jail. We're not going to convict William Penn." And
Right.
then they held out for days and days and days. And but our jury system is based off the Scottish system, and then the Scottish, our Declaration of Independence, ultimately our Constitution, excuse me, is all based off the Scottish Enlightenment. And some really, really smart chaps like Hume and who wrote on criminal justice system. Witherspoon from England, who became the president from Scotland, became the president of Princeton. And yeah, they knew that the right of jury trial, the Magna Carta gave the right of jury trial in 14 whatever, but it was only to rich people. And so our jury system was, everybody had a right to a jury trial for a felony.
Right.
And that's expanded to the states, but Scotland's got this really cool system. They have 15 jurors for the more serious crimes. You have 15 jurors, and they can excuse them, but it's a majority verdict. 8 have to vote for guilty. If you lose 1 or 2 to illness, they can still proceed, but you still got to have 8 out of 14, 8 out of 13, whatever the case may be.
They have to have 8. Okay.
They have, the 3 verdicts, which Paul's talked about before. You got guilty, not proven, and not guilty. But if the jury doesn't reach a decision in Scotland, it's an acquittal. There's no retrial. There's no hung jury mistrial like we have here in the States. It's over. It's done. That's it. Which I think gives incentive to the jury. It's like, well, we can't reach a decision on not guilty. We can't get it on guilty, and so that's a good middle ground. Not proven.
Yeah.
There was a
allows them to
murder.
relitigate later. Right.
Yeah. There was every once in a while, about every 20 years, there's a move to reform that, get rid of the not proven, because there was pretty famous murder case there, and the family was just absolutely convinced that this boyfriend had committed the murder, and frankly probably did, but there was some problems in the case, and so they took it to trial, and they came up with the not proven, and this family in the 90s made a huge push to change the law and get rid of that verdict, that that it be all or nothing. But who knows, the jury may not have been able to reach a decision, in which case he would have been acquitted anyway, or
Right.
because they didn't have the option of not proven, they may just have simply have gone for not guilty.
Yeah.
But fascinating system in Scotland. But
Right.
they're
You're gonna make Paul get a fat head.
well, the Scottish, they invented the world. I mean, they're
Yeah, according to them, anyway.
and Captain Crunch isn't Scottish, so I hope they're not going there either.
Yeah. So Julie Johnston asks, so do you think an exoneration for Stephen Avery would benefit Brendan?
Most certainly, but it's going to depend a little bit on what the basis of the exoneration is. If he gets a new trial based on ineffective assistance of counsel, and then they just end up deciding not to retry the case because they don't have enough evidence or whatnot, that's not going to help Brendan because he has different counsel. But if they exonerate him based on, let's say, what they find, if they let her test the DNA on the bones in the three gravel pit, the 3 piles in the gravel pit, then he could come in and claim, hey, that's new evidence I didn't have at the time of my trial.
Right.
So I'm going to.
Or if it's determined that the state giving bones back to the hall box basically proves that they are Teresa's, and therefore we don't even need to do testing, would that help him too?
if that were the case, but
what else could they have given him? I mean, other than animal bones, right? I mean, it's either it was the human bones or the animal bones, right? I mean, it's not like there's like a smorgasbord of things to choose from, is there?
Well, I think that's why you have two completely different. Tom Fallon's off the appeal now. I think why he's off the appeal is that if they need to,
plausible deniability.
Well, they could just talk about how horrible and stupid he was. He should,
Oh, he's gonna fall on his sword, eh?
Never given him the bones. He's been. They can, and if the state's got to start responding to some of this stuff, they're going to throw Kratz under the bus quickly, right. and potentially Fallon too, just to say, just because he's an idiot, he should have never given him these bones, or.
I wonder if this has anything to do with the timing of Colborn's lawsuit. He's complaining about he doesn't want defamation from them, but maybe he's worried about getting thrown under the bus by the state too, so he can add them to his defamation suit potentially. I don't know. Anyways.
Well, we've talked about that. What was the timing, because the brief was due, and he was trying to time it at the same time. It turns out he filed it the day before the statute of limitations expired. Filed it on the 19th. I think he couldn't get anybody to file it for him. I think the police union came in and came up with some money to file a lawsuit. How much they want to stick behind it and fund it, remains to be seen. But
Right.
it's the police unions, associations are very, very strong along
Right.
the East Coast, and so
So
they might put a lot of money into it, but
right.
I think there's some outside source that convinced him. Because any number of people could have filed that. Could have been Link, could have been, he's relocated to Arizona, correct?
Yeah, I believe so. Yeah.
Sometimes you just try and find somebody to file a civil suit that's willing to do it, and he would be a good logical choice. One, he was the subject of a lot of, he's one of the key guys. Peterson,
Right.
Sheriff Peterson, Link, him, that female sheriff that said he was dirty and whatnot. There was several people, but he's out of state, and they may have just asked him, hey, there. But I think it had more to do with trying to find somebody, him maybe having to come up, get some money together for them to take the case. They finally did, and they, got it in the day before the statute of limitations. I think the statute of limitations had the most to do with it. Because if you don't file it, and they may have said, hey, we'll file it, but we'll give you a month to find an attorney, but we're going to withdraw if you either don't come up with a pile of money.
Right. Right. Okay. Got it. Makes sense. Ashley Hadley says, "What happens if the Hallbox don't give the remains to get tested?" Well, it's only 6 of the suspected bones that they possibly have. So the state should, according to the evidence list, they should definitely have 3 of the bones.
Three sets. There's sets.
3 sets of the bones where these suspected human bones are in these sets of bones. And then out of 6 other sets of bones where these suspected human bones were said to be, bones from those sets were given back to the Hallbox.
Right.
Now, you have suspected human bones in there, and you have animal bones in there. If they weren't handing back suspected... What else?
They had non-bone material, which they separated, and then suspected human bones, and then yeah, but go ahead. But,
yeah, so my whole thing is, even, okay, we have some, I don't know, earth in there, right? Whatever, non-bone material, right? So you're going to obviously have maybe a little debris. So that's fine. We'll add a little bit of debris in there, right? So they either gave the Hallbox a possible human bone, which they believed would be Teresa's, or were reasoning that it may be Teresa's, or they were handing the Hallbox animal bones, right? And for some reason, like, the Hallbox would want that, or they were handing the Hallbox debris from an evidence bag where a bunch of bones were. I mean, no matter what, when it comes down to it, what did they most likely give the Hallbox out of these bags? The suspected human bones, or the possible human bones, as they word it. That's my guess. That's what logic tells me, because if they gave the Hallbox anything else besides the suspected or the possible human bones, then it's insulting. It's absolutely just insulting. Yeah. So I don't know. That's the way I feel about it. So I think hopefully that answers Ashley's question.
Well, so the state's gonna. So we got a lot of steps to get there. So we got, Kathleen Zellner's got to get her motion granted that the state's got to produce that for the quick DNA testing.
Right.
So assuming that happens, then they need to give her the bones under the typical protocol, that they not be destroyed, that they're the evidence chain is maintained,
Right.
et cetera, et cetera. He wants to do it at his lab in Waltham, Massachusetts. And so they're true to form. They want to drive them out personally, under lock and key, and bring them to the lab and eyeball it. So you get that. And then they reach the point where, it's okay, here they all are. And, I'm wrong. And even though it says right in CASO at 1113 and CASO 1114 that they return these bones to the funeral home, and that they didn't distinguish that it was part of the bones. It just said they returned the whole item, less non-bone material. But who knows? I mean, it seems pretty clear in 1113, 1114 they returned those items she's asking for. But the court says, state, you got to give them all the items, all 9 items. Then, it's going to come to, well, we've got 3 of them. You can get started on that. The other 6, we don't have. We gave away. And then it's probably going to take more court wrangling. Yeah. Much, much more.
Right. Let's see. Pom Pom asks, but when a jury makes a decision, doesn't the judge have the right to set aside the jury's decision, or is that only in certain circumstances?
It's in all circumstances. It's called a motion for new trial, which was filed both in Brendan's case and Stephen's case.
Right.
A motion. They were both given new attorneys, and they filed a motion for new trial, and Judge Fox denied Brendan's motion for new trial, and Judge Willis denied Stephen's trial.
Right.
And which is pretty typical. Judges don't usually reverse jury decision unless something those are typically due within 30 days of the jury verdict, sometimes 60 days. So something glaring came out, just, egregious juror misconduct, that something very unusual happened. A judge will grant those, but typically they don't reverse themselves. What you're doing in those motions is just preserving everything you possibly can, because you're going up to the Court of Appeals above that. But yes, the judge can set it aside. It's called a couple of different things. As a matter of fact, there's a thing even before the end of a trial. It's called a motion for directed verdict, where the state rests, and you get up and say, hey, they haven't proven their case on this or that. If Kratz hadn't dismissed the sexual assault, they would have been able to make a motion for directed verdict. And I think Willis, there's no question, he had serious doubts about those 3 claims going into trial, but I'm pretty sure the state knew that Judge Willis was going to dismiss those. No question.
Yeah.
But yes, that is available, but it's seldom granted unless something really unusual happens.
Right. So, yeah, I think that's about it. Let's make sure there wasn't one other question here. When I did jury service, we could come. Yeah, I don't know. Yeah, I think that's about it. So I think we're about done talking about AEDPA for today, folks. Hopefully it's been informative. Hopefully it's been interesting. Hopefully having Travis's point of view on it helps you to understand the legality and the legal aspects of it a little better. And hopefully you guys understand better what needs to be done now to change it or to get it amended. You had something to say?
Falcon, there's just to finish up on that point is
Sure.
I don't think the Halbachs, they don't have a duty to preserve the bones they receive.
Right.
If they were given those bones, then now if they have been preserved, if they're in a casket in the ground, um, there can be a fight to exhume the bones and try and sort out what's what. But they don't have any legal obligation to preserve what was given to them.
Right.
And now I think the state had an obligation under their preservation statute.
Mm-hmm.
It's comprehensive. It covers labs. It covers the district attorney's office. It covers law enforcement agencies, all of them. I think they had a duty to preserve those bones, and
Right.
under the statute, and they, what the consequences for not preserving those bones.
Yeah.
That's the statute's silent on that. And,
Hey, look, if they disgraced the hall box and handed them animal bones, then the state might still have it. So,
well, if you guys
we'll have to see.
You guys saw Innocent Man.
Yes.
And I've been saying this from the beginning, that this could cause a schism between the Hallback family and the AG's office.
Right.
That mother, you saw what it did to her when she agreed to exhume that body.
Right.
And she gets a call, hey, they're digging up your daughter. No, that can't be. We had an agreement. You saw what that did to her and what it made her think of that DA.
Yeah.
That's what I've been talking about. The other thing to take from that is it's impossible to try and figure out how you would process the murder of a child. And, it takes something like that to get a family to flip.
Yeah, I can imagine. But I can imagine how that would do it.
Yeah, why doesn't this person or this family want to have this done? It's because over and over and over again, they're the police. We got the right guy, and you're just. And Grisham said it. We're just not conditioned to think anything other than police always get it right.
Right.
That's all I had. That's all I had to say.
I think that's changing nowadays, but yeah. But anyways, all right.
Well,
so
we seem to have to relearn it every 10 or 15 years. We seem like there's a high-profile case like this, and everybody's outraged, and then hopefully the right result happens. Takes typically 15, 20 years. They get out, and then it seems like we have to relearn it. every 15, 20 years,
Yeah.
which is unfortunate. Because
Yeah.
there are a lot of people that don't have an HBO 3-part series made about them with funding from the guy who produced The Hobbit and the Rings trilogy, or that have a book written about them by John Grisham,
Right.
or that have, you know,
A Netflix
got
documentary
going on with this case, you know, and it's 4% of people in U.S. prisons they think are actually innocent.
Right. 4? Yeah. Okay.
You know, so is that acceptable to you or not? Some people that's an acceptable figure.
Yeah. I can imagine for some people maybe it is. But
for
we
other
have
people,
data telling us we can get that number to be even better. So to just say, oh, we don't need to, even though there's data telling us we can improve, we don't need to, because you know what, it's cool. You know, how many less wrongfully convicted are we really going to end up with? It's fine, just leave it, right? I don't agree with that attitude. We have data coming in telling us what we're doing wrong, how we're doing it wrong, getting it wrong, and it's something that can be looked at and corrected, or you know, amended or something, and to ignore it is just silly.
yeah. Well, I hope I answered whatever questions there were on AEDPA, how it came about, what the history was, and if people want to talk about it, you know, in a much more detailed way, then I can pick up. We can talk about the 4 cases, but you know, that's how it came, and you know, I enjoyed talking about it, and hoping some more people can understand what it's about, and why it's not a good thing that the writ of habeas corpus is it's sacred in the U.S.
Supposed to be. Yep.
It was.
Whoops. Sorry.
Go ahead.
I was just gonna say, and with that, we'll go ahead and hand it over to Stacy Seabrook here, and we'll see you guys again real soon. We'll revisit AEDPA, possibly get into some of the case law for you guys to get a little deeper understanding of. I think, as Travis was just alluding to, those of you who are interested, you can go into the Hangouts chat after this. There's always plenty of people there talking about the case, so feel free to go there. I'm sure my moderators will be posting a link for you here momentarily. And with that, let's cut to Stacy Seabrook.
Wisconsin can be so cold. The scales of justice can erode. If we accept lies big and bold, or we forget we live on Avery Road. We live on Avery Road. Should be easy to see. This could be you,
could be me.
We shouldn't
Should
sit
sit by idly, accepting everything that we are told. I live on Avery Road.
I live on Avery Road. On Avery Road. There's something going on. Freedom is in danger. Agents of the state, they're taking children from the manger.
Oh, they will sacrifice your kid.
Take Brendan Dassey, that's exactly what they did. They needed someone, oh, Jody wouldn't flip. They looked around, saw him quick. Oh, it made so much sense why. Oh, Brendan Dassey, he was Stephen's alibi. There's something going on in Wisconsin that's not kosher. We better stop, let's all take a look closer. Oh, they will sacrifice your kid for Brendan Dassey. That's exactly what they did. They visit him once, they visit him twice. They make him feel so safe. Sandwiches, soda, so nice. No cameras rolling and under no lights. Who knows what went on up in Fox Hill Monday night? There's something going on. Freedom is in danger. Everything about this can't get in stranger and stranger. All we know, they will sacrifice your kid. Oh, Brendan Dassey, that's exactly what they did. March 1st, alone in a room with Bert and Ernie. No parent present and no attorney. 4 hours later, with a touch of the knee, they finally get Brendan to agree. There's something going on. I said there's something going on. Oh, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. There's something going on. I said freedom is in danger when the agents of the state can take the children from the manger. Oh, they will sacrifice your kid. Take Brendan Dassey, that's exactly what they did. Take Brendan Dassey, oh, that's exactly what they did.
All right, folks, that's it for now. We'll talk to you guys next time. If you haven't already, please hit subscribe. We'll see ya.